Can my lawful permanent resident spouse sponsor me for a green card? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our office here in St. Louis, Missouri. When a U.S. citizen marries a foreign national, that U.S. citizen is able to sponsor their spouse for a green card. And there are an unlimited number of these kinds of green cards available. That is, Congress has not put any kind of cap or limit on the number of green cards that can be awarded to the spouses of U.S. citizens. However, that is not the case for the spouses of lawful permanent residents. So if a lawful permanent resident marries someone from overseas and that person's in the United States, they might want to get a green card. But the process is different than it is when a U.S. citizen applies. When a U.S. citizen applies, they can file the I-130 petition for alien relative and the I-485 petition for adjustment of status for the foreign national all at the same time. And the foreign national can wait in the United States while that case is pending. And it just takes about 9 or 10 months, and at the end of the process, the spouse of the U.S. citizen has a green card. But not so with a lawful permanent resident spouse. When a lawful permanent resident applies for a foreign national, their spouse, to get a green card, it's a two-step process. First, you have to file the I-130 petition for alien relative, and that can take about 6 or 7 months to get approved. And then you have to wait for your green card priority date to become current. Now, what's a priority date? When you file that initial I-130, your case is receipted, and it is assigned a priority date. And a priority date is basically your line ticket. It's your place in line where you're going to have to pay attention to find out when your visa becomes available. In other words, because Congress has capped the number of green cards that are available for the spouses of lawful permanent residents, there is a backlog. And right now the backlog is running a little over 2 years. And so what you do is you file the I-130. And let's say you filed it on April 1st, 2018. You would have received a receipt notice and it would say the priority date. And then every month you have to check something called the Visa Bulletin. The Visa Bulletin is a document that is issued by the State Department once a month, and it tells you what cases that they're working on. So every month they're working closer and closer to your priority date. So right now there would be people whose priority dates were from 2 years and a month ago, and their visas would now be coming current, and now they can apply with their approved I-130 for an adjustment of status. So at that point they file the I-485, they file the I-131 application for a travel document and the I-765 work authorization. And this is when you're going to have the actual interview to adjust that status from that of whatever status you have to that of lawful permanent resident. And that brings up an interesting point. If you are in the United States, the fact that your lawful permanent resident spouse has filed a green card application for you does not in and of itself give you any kind of status. So if you're going to do that, you have to maintain your status those whole 2 years while you're waiting for your visa to become current. Or you're going to have to leave the United States because you don't want to do what's called accrue unlawful presence. You don't want to have a bunch of time in the United States out of status, because being married to a green card holder does not protect you like it does when you're married to a U.S. citizen. So you really need to think it through. And I would not recommend that a lawful permanent resident file for their spouse without the help of a qualified immigration lawyer. There are simply too many moving parts. Another problem is that if you're on an F1 student visa, say a non-immigrant visa like an F1, and you apply for lawful permanent, or you have your spouse files an I-130 for you, that demonstrates immigrant intent, and that can show that you have an intention to stay in the United States, which is inconsistent with your F1 non-immigrant visa. So you're really going to want to think it through. You're going to want to do some research, and you're probably going to want to talk to a experienced immigration lawyer before you try something like this. It's not the easiest of maneuvers, and there's a lot of, like I said, moving parts. So if you have questions about this, be sure to give us a call at 314-961-8200. You can email us at info@hackinglawpractice.com. If you like this video, please be sure to share it on social. Make sure that you subscribe to our YouTube channel, and then come find us in Immigrant Home, which is our Facebook group. Thanks a lot. Have a great day.